The next case is Mace versus M&T Bank.
May it please the court.
Counsel.
I'm Mark Stupp, a counsel for the appellants. I would request 5 minutes for rebuttal.
Very good.
Your Honors, there are 3 reasons why I submit this court should reverse the final judgment of foreclosure and remand for an involuntary dismissal. The first is one that this court, Your Honor, Judge Silberman just wrote about recently, including in a case I was counsel in Edmonds, as well as the Allen decision, because there was no competent substantial evidence showing that the default letter in this case was actually mailed. The argument that my opponent relies upon, and which the trial court ruled upon, is that the plaintiff's witness testified that she had, quote, personal knowledge that the letter was mailed based on notes and business records which were not admitted into evidence. That is clearly inadmissible hearsay, to which I contemporaneously objected, and this court's decisions in Stass and Heller are directly on point in that regard. The witness also tried to testify that she knew the letter was mailed because someone with McCalla Raymer, a law firm with whom she was not employed, told her that the letter had been mailed. Well, someone telling you that something happened doesn't give personal knowledge. That was also an admissible hearsay, for which I made a contemporaneous objection. So those were not a basis in which to say that the letter was mailed. That was not competent substantial evidence. The only thing that left was the receipt, and the receipt was admitted into evidence.
Before you go to the receipt, there was no clear testimony from the plaintiff as far as the standard business practice between the bank and the law firm in terms of we prepare the letter, we get the envelope ready, we turn it over to the law firm, and their standard business practice is they double check it, sign it, send it, or whatever.
No, that didn't happen, and I submit even if that had happened, that the witness would not have been able to give competent substantial evidence of that because she wouldn't have personal knowledge of a different company's routine business practice, just as you wrote about in
But it might work if there's an principal-agency relationship, correct?
I could maybe see that if you had actually proven the principal-agency relationship, and I actually argued that at the time too, but there was no proof of a principal-agency relationship sufficient for that type of showing to be made. And the way Your Honor wrote it at Edmonds and Allen was just how I had argued in the Edmonds decision, is that the witness has to have personal knowledge in order to testify about a routine business practice of an organization. If you're not employed with an organization, I think that's a very difficult thing to do. I think that it is possible. For instance, there's a case out of the Fourth called Balcasoon that does that in a third-party vendor context for mailing letters, but it would have to be something that the witness has a basis to testify about. And there was nothing here about a routine business practice of this law firm mailing a letter on its behalf or something like that. And for what it's worth, I have never once seen, other than in this case, seen a law firm purportedly mail a letter under circumstances like this where it's on a bank's letterhead. So that's why I got to I'm arguing comparing the letter to the receipt, because if you look at them side by side, and I actually brought them up here, records 635, 636, and 637, there's just nothing linking the two. For instance, M&T Bank is identified on the letter, but it's not identified on the receipt. The receipt identifies McCalla Raymer, but McCalla Raymer is not identified on the letter. The receipt has a certified mail number, and that certified mail number is not on the letter. And I've done enough of these to know, and I suspect Your Honors have as well, that when those match up, the certified mail number is listed on the letter, and that's just not the case here. In fact, this receipt isn't even dated. So there's just no way to look at this receipt and to say that this receipt is evidence of the mailing of this letter, because there's nothing that links the receipt to the letter at all. And I submit that the receipt...
Her testimony does not, if I remember correctly, her testimony does not indicate that she prepared both the letter and the return receipt.
Totally correct. She did not prepare either of them. And I don't think that the receipt even should have been admitted, because my argument at the time and in the briefs here is that how did this witness have a basis to say that the receipt was made at or near the time of the event by a person with knowledge in the ordinary course of business, etc., as required under the business records exception to the hearsay rule, because it's a McCalla-Raymer document that has no relationship to the company that she's worked for at all. But even if you disagreed with that and thought the receipt was appropriately admitted, there's just not anything on it that links it to the letter or that shows that the letter was actually mailed. So without any competent substantial evidence that the letter was mailed, that's the first basis to reverse and involuntarily dismiss on remand. The next problem is that this is a pretty unusual fact pattern in some senses, but in others this is an issue that comes up a lot. Here we have a prior case, a prior lawsuit that was not only dismissed, but dismissed with prejudice, and that order of dismissal entered in August of 2013. Nonetheless, my opponent sued on default dates going all the way back to 2010. That's years of defaults, even though those defaults had already been adjudicated on the merits by virtue of the prior order of dismissal with prejudice. Now, my reading of Singleton and Bartram clearly prohibits that. You cannot, when you have a case that was dismissed with prejudice and defaults adjudicated on the merits, you can't include those defaults in a subsequent suit.
Now, this complaint alleged all subsequent defaults, so on its face it brought in defaults that would not have arguably been barred by the prior judgment, correct?
That's true.
I know, I've read all the cases that you're talking about. I'm not convinced they say what you say they say, but I was just noodling over something. I wonder if in that context, collateral estoppel is really the more appropriate doctrine to be applying here, because it doesn't seem to me, or at least arguably, it's not, the subsequent suit is not a suit on the same cause of action. It's a suit on a different cause of action that has got some issues that were previously decided. I was interested in your reaction to that.
I couched it in terms of res judicata and collateral estoppel in the first issue of my initial brief. So I think that's a distinction without a difference for purposes.
Well, I think it would make a difference in this respect. Collateral estoppel, unlike res judicata, does not extend to every issue that was or could have been raised. It extends only to issues that were actually litigated and decided. And it's not clear to me exactly what the order dismissing the 2012 complaint or the 2012 suit actually decided.
Well, I understand the distinction you're trying to make, but as I look at, for instance, the Whidden decision out of the first DCA in 2015, the holding of that...
But in Whidden, right, the defendant conceded that the complaint was defective. What they were fighting about really was, please don't cancel our note because it's not appropriate under Cazell.
Okay, and that's part of the ruling there, but the other part of the ruling in the holding of the case is we affirm the trial court's order to dismiss the foreclosure action to the extent that default dates pleaded by GMAC included dates preceding the dismissal of the 2010
the
case.
Defendant conceded that there, correct?
I don't read that as a concession. I read that as that's what they're saying that the law is, and the first and the fourth followed that in Neal and Crondas as well. In both of those cases, the inclusion where you have some defaults which are barred by res judicata or collateral estoppel and some defaults which are not, you have the first and the fourth DCAs both saying the entire case gets dismissed. That's what both DCAs have held. Now, I understand that this court, in a different but somewhat similar context than DeSylvester, said, well, we're going to allow the case to go, the foreclosure to go forward because some defaults were barred, but some of them weren't. And that's where, if that's what you're thinking as you're asking that.
You said that in Bottolari too, and your response to that is one is limitations, the other is res judicata, and I agree that's a difference. I guess I'm trying to figure out why that's a difference that matters in principle.
Well, Bottolari was issued before Bartram came out. I don't think that you can read Bartram and Singleton in a way that allows you to avoid dismissal as a foreclosing lender when you're suing on defaults which are barred as a matter of law because of a dismissal with prejudice in a prior case. I have not seen a case that holds that from any DCA. I don't think that there's a way to say that and not certify conflict with Whidden, Krondus, and Neal, the cases I've cited in the brief, particularly the holding of Whidden. And I understand that Whidden also dealt with canceling a note and mortgage, but ignore that portion of it and read the holding that says we affirm the dismissal of the prior case because some of the defaults were barred and some of them weren't. So there's no way to do that and not certify conflict. But even if you think that following De Silvestre is appropriate on this fact pattern, even though De Silvestre was a statute of limitations issue, where I bring you back to then is the next issue is there's no way that fixes the 22 letter problems. Okay, because here you have a paragraph 22 letter that required $435,000 to cure the default. On its face, it said that was for payment defaults going back to May of 2010, but at trial it was undisputed, and the lender's own witness admitted that what that amount, that $435,000 actually consisted of, was amounts going all the way back to October 2006, the initial default, which they weren't even suing upon, and which they agree as a matter of law were barred by the statute of limitations. So the math, which I did...
Something that nobody argued in this but struck me is the statute of limitations issue is an affirmative defense, and it can be waived by not being timely raised. So does that make the demand letter that otherwise adds up the numbers correctly, or arguably adds up the numbers correctly, does that make the demand letter deficient? In other words, does the lender have to anticipate that they are going to lose on a statute of limitations defense as to certain of the charges?
Well, I think the answer to that is yes, because the whole point of a paragraph 22 letter is specify the action required to cure the default. You're supposed to get the letter and know what you have to pay in order to cure the default.
Why can't the lender take the position that you stopped paying in 2006 based on the terms of the note and the mortgage? Here's what you owe to cure the default that exists, and your position is, I think, well, they really can't collect from 2006 to either 2010 or 2014, so they shouldn't be demanding it. But that's an affirmative defense issue. I don't know that it makes it deficient from the get-go.
Oh, I see the point that you're making now. One, because they didn't argue that, so it's waived. But two, you don't need to get to that question in this case, because in this case you have a prior lawsuit that dismissed with prejudice. And when that prior suit was dismissed with prejudice, they clearly were not entitled to demand amounts which are barred as a matter of law. They're not entitled to collect those amounts as a matter of law. Like, I think there's a Middle District decision out of Tampa which actually holds in 2016 that it violates federal law if you sue on amounts that you're not entitled to collect. So I submit that where they're barred both by the statute of limitations and res judicata and collateral estoppel, that they are not allowed, that it does not substantially comply to say pay $435,000. My client didn't have to pay that. It was undisputed my client didn't have to pay that. It was undisputed that all that my client had to pay was $56,700. That was the amount as of from after the dismissal of that prior case with prejudice in September of 2013 through the date of the letter, $56,700. That's what he should have had to pay. That's what was necessary to cure the default. That was his default, because all the other defaults were eliminated as a matter of law by virtue of the dismissal with prejudice, which operates as an adjudication on the merits. There's simply no way that they can get away with that, and that's why I think it's telling at trial my opponent didn't even have an argument on that issue. Didn't even argue it. Their only argument at trial was to argue prejudice. And then in this court, they really don't even have an argument on that issue either. They don't even try to say that the letter substantially complied. And I think we all know, as unfortunately liberal as this court has treated the substantial compliance standard, notwithstanding how I've tried to argue it, I don't think there's any way that anyone could say that a letter substantially complies when you're only supposed to pay $56,000 and the letter requires $435,000. I can't imagine that we would take substantial compliance that far, and from the smiles, I appreciate that. I don't see a way around that.
I think it's a comment about how liberal this court has become that has created some chuckles.
I was trying to word that in a respectful way while still articulating the point about how the court has taken substantial compliance further than I would have liked to, but I don't see that you could take it to a level where $435,000 is okay when you only had to pay $56,000. And so that was my point there, Judge. Yeah, and I think my opponent not even arguing that issue or that point speaks volumes on that. Now, I don't think that prejudice is an argument that saves them here, because this court in Malam even said, we have never employed a prejudice analysis in this context. That's something that I've argued many times. I'd like to think I've succeeded on in this court, never employing a prejudice analysis in the paragraph 22 context. There are a variety of reasons why it shouldn't do so. I think principally because the prejudice concept comes from the insurance context, which is just fundamentally different, because there it's the concept of prejudice inures to the benefit of consumers. Here the roles are reversed. We shouldn't create a prejudice analysis that inures to the benefit of financial institutions. Even if you did employ a prejudice analysis, the Florida Supreme Court says in Macias it should be the plaintiff's burden, not the defendant's. How could the plaintiff possibly say here that there was no prejudice? There certainly was not any proof of no prejudice when you have a letter that demands hundreds of thousands of dollars more than what was required as a matter of law. Now, even if they somehow got past all that, this was I couldn't invent a better fact pattern for prejudice here than having a client who works with a company called Save America Homes, a nonprofit that is designed to help people in foreclosure, who testifies and gives undisputed evidence that he had access to investors and money sufficient to cure the default if the letter had included the correct information.
Mr. Stoker, you're at the 15-minute mark.
Thank you, Judge. So I submit that for any of those three reasons, a reversal and involuntary dismissal is required. I'll save the rest for rebuttal. Thank you.
Good morning, Your Honors. Charles Gufford on behalf of McCullough Raymer and the plaintiff M&T Bank. May it please the court. May it please counsel. Your Honor, as to the first issue, I think if the court reviews the transcript of the trial itself as to whether the letter was sent, I think there's substantial competent evidence to support that it was sent.
Well, I know she said she had personal knowledge of it, but I have to tell you, I'm going to need your help on this one, because I read the transcript substantially the way Mr. Stopa does, that when you break it down, that alleged personal knowledge came either from business records that weren't in evidence or from her conversation with McCullough Raymer, both of which are, to my mind, classic hearsay. Why am I wrong about that?
You're not, Your Honor, except for the fact that she said she was personally involved in the process itself, helping with the mailing of the letter, which is in the record, Your Honor, which I can cite to if Your Honor was.
Yeah, you want to give it to me?
Yes, sir. Record at 492, 25, 493, lines 1 and 2.
Yeah, but didn't it subsequently come out that she just kind of worked with McCullough Raymer on that stuff and that she really didn't know whether it was sent or not?
No, she said that it was sent, and obviously she was backed that up based on her business record that she knew it was sent, that she was relying on, which is hearsay. However, she also indicated in her own testimony that was her personal involvement was to make sure it was mailed and mailed accordingly.
But she turned it over to the law firm. I mean, I think it's undisputed. She turned it over to the law firm, so it suggests her language might have been a little bit overstated, that she was directly involved in the mailing of it. I mean, that seems to me to be too much inference to draw from her testimony.
It may, Your Honor, but I believe you can also look at it that she was directing as counsel, their agent, as their attorney, how the process should go when mailing the letter out, and she was confirming that it was mailed with her personal direct involvement.
But that confirmation that it was mailed, that's the inference you need, right? And that inference only comes from what McCullough Raymer told her.
It is, and it is also from the business records that she relied on. It wasn't just, it was her personal knowledge looking at her business records.
Those are hearsay too. I mean, in other words, I don't understand how you get to the inference that you want without inadmissible evidence backing it up here.
I understand, Your Honor. I understand. Your Honor, other than that, I can also indicate that, again, you're right, based on her personal training and what she'd known and done with the law firm over her personal conversations herself with it, confirming it was sent. That's how we know it was sent, Your Honor, and the fact that she also was relying on.
I mean, is this one where maybe you guys just ought to think about conceding?
Your Honor, I would still say no, just to the extent of the other two issues that I think that the court validly brought up based on the statute of limitations, which I think does need to be addressed by the court. what the court just said, based on the subsequent defaults issue, but I don't believe the dismissal with prejudice had any effect on stating a new default date that's within 5 years. The default date alleged in the complaint was within a 5-year period from the filing date.
Although it's interesting, the language that the Supreme Court uses seems to be along the lines of needing a date after the date of dismissal.
Correct, but if you look at the cases subsequent to that, even from the recent 50CA case that came out recently 2 months ago, Your Honor, they're looking at a date that's just within a 5-year period, because they even looked at dicta.
And I'll tell you, that makes sense to me, but the language of the Supreme Court, and I don't think the Supreme Court has receded from that. The Supreme Court has said, as long as they allege a date that's after the date of the dismissal of the other case, then the bank is good to go.
And that is in this case, Your Honor, which is obviously the Bartram appeal. However, or the Bartram opinion, excuse me. I have a problem, and I don't know if the court has any better stance than I do, of making out, because there's certain dicta that the court relied on, the Supreme Court, in saying that so much as, and they cite to the 5th District Court in Bartram, the reason that a new and independent right to accelerate would mean that each new default would present new causes of action, regardless of whether the payment due dates had been accelerated in the first foreclosure action. So regardless of acceleration, as long as we're using a date that's within a 5-year period, why can we not use that in a cause of action, Your Honor? And then if you go on, Your Honor, also in Bartram, they cite to the fact that each payment default that is less than 5 years old creates a basis for a subsequent foreclosure or acceleration, which is exactly what we have in this case, Your Honor. And then again, subsequent and separate alleged defaults create a new and independent right, the mortgage, to accelerate payment on the note in subsequent foreclosure actions. And then again, going on. With each subsequent default, the statute of limitations runs from the date each new default providing the mortgagee the right but not the obligation to accelerate. So those dates, although they may have been accelerated, were only accelerated when they occurred, which would have been that May 1st, 2010 date. So we had 5 years from that date to refile the new cause of action, or file the new cause of action, excuse me. I think as to the prejudice issue, Your Honors, moving on to the breach letter, obviously if the court finds that it wasn't sent, we don't get to that point. I agree with that. However, I think we're having a problem meshing the case law with what the lender's supposed to do to give notice, because counsel could easily come back here and say, you didn't give me the right number to reinstate, because obviously the terms of the note and mortgage require that the borrower pay back the full amount of the mortgage. Again, a statute of limitations issue is a procedural bar, not a bar to collect the full amount due, unless, and I do agree, if an order states otherwise specifically, but in this specific case involving, the orders don't say that at all. All right. With that being said, Your Honors, I would request that the court affirm the trial court's order of judgment. Thank you.
Thank you.
May it please the court. In Bartram, the Florida Supreme Court clearly requires defaults after the dismissal of the prior case. Why is that? Because the dismissal of the prior case serves to decelerate the balance due, and that deceleration concept is how the Florida Supreme Court explains that the statute of limitations doesn't bar foreclosure, even though 5 years passed after the loan was initially accelerated by the filing of the prior complaint. Okay, so and that also puts the parties back in the status quo such that a borrower can resume making normal monthly payments. Now, when you accept that the dismissal of this prior case in August of 2013 allowed my client to resume making normal monthly payments, you're necessarily saying that they can't be suing on any monthly payments prior to that, because there weren't even any monthly payments due, because the loan was accelerated when the complaint was filed and decelerated when that case was dismissed. That's why there's nothing in Bartram that requires a borrower to make any payment as part of resuming normal payments after a prior case gets dismissed. There's nothing in Bartram that requires that he pay the amounts that are accrued during the pendency of that prior suit. Nothing. Instead, the holding of the case requires payments only after the dismissal of that case.
Would there be any different analysis if the first case were dismissed, for example, for failure to send a proper notice of acceleration, so that it's basically void from the get-go or voidable from the get-go, versus a case where it goes to trial damages aren't proven, so the case is involuntarily dismissed there. Would there be any distinction as to which payments should be collectible versus which ones should be barred?
I mean, I think no, because the Florida Supreme Court makes no distinction in that. You're not going to, I couldn't come in here and argue, well, the statute of limitations may not apply in that context, but it applies in this one, right? No matter what the reason for the dismissal is, a dismissal decelerates the balance due and allows my client to resume making normal payments.
You're conflating, though, in that argument, the statute of limitations versus either collateral estoppel or res judicata.
And that's why I think collateral estoppel might make a difference, right? In Judge Silberman's hypothetical, arguably the most that was actually litigated is whether the lender had satisfied a condition precedent to bringing the action, not its entitlement to recover on the underlying payments.
Okay, but you're thinking about it in terms of what defaults can be sued upon in the pleadings. I'd ask that you think about it in terms of what defaults can be demanded in the 22 letter, because what you can sue upon in the pleadings is an issue the DCAs aren't agreeing on right now, and the Florida Supreme Court's deciding that. But what defaults can you demand in the 22 letter? That's undisputed. You can't require those amounts which were prior to the dismissal of the prior case. That's why it's so clear, and they're not even arguing otherwise, that 22 letter had to require $56,700, the monthly payments from September 2013 after the prior case was dismissed up to the date of the letter. Regardless of the reason for the dismissal, whether it's with prejudice or without or whatever the reason for the dismissal is, that's what those 22 letters have to do. It should have required $56,700. That's what Bartram provides. And so we could argue all day about what you can sue upon in the pleadings, but the default letter, there's nothing that allows you to go back prior to the dismissal of the prior case and include those amounts in the subsequent default letter. And so even if you don't agree with me on the pleading issue based on D. Sylvester, cement you should still be reversing based on that additional issue as well, how the 22 letter just doesn't substantially comply because there's no way to read Bartram that allowed them to sue on amounts which were prior to the dismissal of that prior case. Because the dismissal decelerates the balance due. We're allowed to resume making normal monthly payments, and there's nothing that required us to pay the monthly payments that would have been due while that loan was in an accelerated posture during the pendency of that prior case. That has to be the law, and if you think about, try to imagine a scenario where I were here arguing the statute of limitations doesn't bar foreclosure based on the nature of the dismissal or something like that, you would conclude it has to be, no matter what type of dismissal it is, dismissal decelerates the balance due, allows the borrower to resume making normal monthly payments, and they can still sue again, but they have to sue only on amounts which are after the dismissal of the prior case, and that's certainly what the 22 letter has to say. So even if their inclusion of amounts, inclusion of defaults that they shouldn't have sued upon pre-dismissal is saved by the all subsequent defaults language, that's not a problem you can fix when you do the 22 letter wrong, where you have a letter that demands hundreds.
If you want to take a moment to conclude.
So for those reasons, as well as for the no competent substantial evidence the letter was mailed, this court should reverse and require dismissal. Thank you, Your Honor.
Thank you, counsel. We're going to take a 10-minute recess.